Good afternoon. This is the House Judiciary Non-Civil Committee. Apologize for the late start. It's a function of the day. We at our last meeting, we ended with testimony on House Bill 1153 by Representative Levitas. The way we left that was that we're going to have a substitute drawn to tighten up a couple of provisions, and we agreed that we go ahead and carry it over to the next meeting. Here we are. So let me go ahead and recognize Representative Levitas to speak to his substitute for House Bill 1153, which I understand is in your folder. Representative Levitas.
Thank you, Mr. Chairman. As you said, in the last meeting, I had brought to the Chair's attention we want to make substantial revisions to the bill based on comments that I've had. We have done our best in the 2-week break to work through those issues, and I think that we will continue to work on them if there are questions after today. Certainly I would be committed to do that. I believe that the Chair sent around a copy of the sub around February 13th, so it should have been with members for a long time. The only thing to add to that is that we have come up with a definition of neglect, which you will find on lines 20 to 23. We have spent a great deal of time both going in expanded definitions and shorter definitions, and ultimately we came around to believe that the best way to define neglect is to use the definition of humane care that's already in existing law under 4-11-2, and you'll find that on lines 21 through 23. The other references to humane care and to veterinary care and to shelter that were in the bill have been removed. And again, this adds lines 40 through 45 discusses the standards for the felony of aggravated that includes a knowingly causing the death anytime you deal with torturing of an animal, and the last is subjecting them to neglect that actually results in the death of an animal. Without the death of the animal, you'd be back in a misdemeanor. The only other things to point out is that that are new in this bill from current law is that the offenses are measured within 5 years by date of arrest, so that if you committed this offense in 1970 and then again in 2009, you would not find yourself caught by the higher standards of the bill. And that, Mr. Chairman, is what we have done in the opposition.
Questions for the author, Ms. Abrams?
Thank you. Mr. Levitas, on lines 20 through 23, I understand the reference to humane care as a standard. My concern is about the removal of willful neglect. It seems to remove any mens rea requirement for this provision, so that if I've asked someone to take an action on my behalf, their failure to take that action would redound to me. Can you explain whether or not that's true?
Well, in my reading of the bill, and I apologize, I just realized I didn't have the mic pushed. My reading of the bill, my understanding, having gone back and forth, was I'd answer that in two ways. One, that the willful neglect standard was so high and so and raised such a high standard that they were not able to get convictions even under the extreme circumstances that were testified to last time we were here. But again, even with neglect, and especially when you're dealing with criminal neglect versus civil neglect, I don't think it would be sufficient that the person that you hired failed to show up. Now that person might be accountable, may or may not be accountable, but the mere fact that you hired somebody and that person didn't show up, it would not, in my judgment, rise to the same level as it would in an ordinary context of neglect in a civil context.
If I can follow up with one additional question. So let's assume it's not someone I hired, it's just my next door neighbor. I'm leaving town, I ask my next door neighbor to look after my dog. My next door neighbor fails to do so, or something happens and they, for some reason, can't do it. This failure would constitute neglect, and they would then be subject to this provision, or would I?
I think the neighbor would be. You having made appropriate steps, unless you knew this person was unable to provide any care, you couldn't just go and say, take care of it, and go to your 5-year-old neighbor. You might be under the case of willful neglect in that circumstance. But if I go to you and ask you to care for my animal, and I have no reason to believe that you won't do that, we've agreed to it, you understand what's being done, I leave town, you've just decided you don't want to do that, while you might be subject to it if there was a duty, and you may or may not be, but if there was a duty that was found on you to care for that animal, and then you neglect to care for that animal, don't provide food or water or ventilation for a week, I think you could be prosecuted, but I don't believe that I could be prosecuted.
If I can ask one final question. So let's say I'm the neighbor and I end up getting sick and having pneumonia and I can't do it either. I have now failed to carry out this act. under the terms and statutes, and you come back, you've discovered that your dog is now harmed because of my failure, and you don't understand why I didn't get out of my sick bed and try to drag myself to the door to take care of this, and I have a reasonable explanation for it, but you don't hold it to be adequate. You go to the DA or prosecutor and ask them to pursue this. Would I still, as the neighbor, have committed the act of failure that would then make me subject to this provision? Because I simply agreed at the very beginning, before my terrible bout of pneumonia, agreed to take this action for you.
Well, I think under the circumstances you presented, the answer would be no. And I don't think you would find a prosecutor in the state. Now, if you have the sniffles and don't feel like going, that's one thing. But if you're bedridden with pneumonia, I don't think you're going to find a prosecutor in the state that would take that case and try and prosecute you for criminal negligence in this arena. Again, what we're talking about is somebody who has just decided, I don't really care about the condition of this animal, and I'm not going to provide food, I'm not going to provide water, and I guess if they can survive, they can survive, but if they can't, they can't.
Thank you.
Doesn't that really go to the issue of 411.2? And maybe we could dive a little deeper into exactly what that provides. Or, are you in a position to discuss that?
Well, I am, and also I believe that counsel has given definitions, and I don't unfortunately have it in front of me, but in your summary, she's provided both definitions of humane care as well as what adequate food and water are. I do have 411.2 in front of me, but it's under the summary for the bill, the first thing it talks about is 411.2, the definition of humane care and the definition of adequate food and water. And again, one of the things I want to make clear, what we found incredibly difficult was to try and legislate for every single circumstance, and I don't know how we can do that, and I'm certainly open to have those discussions, and everybody I've talked to, I think, to a person can tell you that I have welcomed them to give us language, and I continue to invite anybody that thinks they have a better way to go about this to talk about that. But when we talk about adequate food and water, keep in mind that the definition means food and water which is sufficient in amount and appropriate for the particular type of animal to prevent starvation, dehydration, or a significant risk to the animal's health from a lack of food or water. So we're not talking about Skippy being outside and it's a little hot and we should think he should have ice water there. Does it rise to the level that you're talking about serious injury to, or the threat of serious injury to the health of the animal? So it's again, could we make this fact specific to every situation? I think the answer is no. But I do think if committee members have a way that they think would be a tighter version, I think that I'd welcome those suggestions. We've certainly wrestled with it.
Mr. Vice Chairman.
Thank you, Mr. Chairman. What about a situation, I'm looking at the language on lines 24 through 26, talks about an act, an omission, or neglect. What about a situation where if someone clips their dog's nails too close or something? I'm not trying to say something that's crazy here, but try to give some real examples of something that might cause pain. But you clip your dog's nails too short, or they do something that is a routine sort of act that's going to cause physical pain or suffering to the animal. That technically would be a violation of this code section, wouldn't it?
I would say no, and if you look at the first word on line 25, that's where I think it modifies that term. It's unjustifiable physical pain. If you're clipping your dog's nail, I don't, again, think there's any prosecutor in the state or any reasonable person that would say if you happen to clip it too short, that's unjustifiable physical pain. You were trying to groom your animal and you made a mistake and clipped it too close. Now, if your point is to try and pull their nails out because you think it's funny, then that would be unjustifiable physical pain. You ought to be captured by the statute.
No, but when you start using the word unjustifiable, if you get into a technical situation, how is your conduct in clipping the nails too short? How is that justified? I've got some issue. I don't have issues with the intent of the bill to try to do something to give some protection to these animals that are being abused, but I'm a little bit wary of the language. I'm concerned that it needs to be tightened up.
Well, I guess the justification is, as you well know from being both a prosecutor and defense attorney, that is a bedrock principle within the law. And again, I don't know that it is possible to come up with justification in every circumstance and tailor a statute to say this is what justification means. At some point, we have to be willing to apply what I think is a reasonable person standard and trust. Again, I mean, the prosecutors are out here. I don't know if they're here today. Would tell you they got plenty of cases out there without having to worry about whether or not somebody clipped their dog's toenails too close. And we can come up with a bunch of different scenarios that involve those things. But again, I guess I would put it back on you. And can anybody find a case where anybody's been charged with something like that, where they've clipped their dog's toenails too
Well,
short?
I mean, you know, there's a lot of things out there that you might not expect to find something on the books already. But I mean, we don't have a law like this on the books right now. So
actually, that's current code. The only thing that's not current code is striking the word death or and striking the word willful. But 24 through 26 is current code.
Current code 24 through 26, except for those strikes that we have there, is
Right.
is
That's
current language.
Current language.
Okay. Well, I'm learning something there. You know, I guess when we look at the term unjustifiable, I kind of go back towards what Representative Abrams was saying, that maybe that we need to look at the mens rea requirement, and rather than look at justification, we ought to look at whether there be it's a willful act. That would just be one suggestion for how to perhaps deal with that issue.
And again, the nature of in fact, the impetus for bringing this bill from the prosecutors was that the willful neglect made it, so, first of all, was unclear and unambiguous, and made it
Right.
essentially impossible for them to get convictions in many of these cases, even in cases that you and I would both agree ought to be prosecuted. And I think the last time we were here, one of the examples they gave was a cat who had been duct taped to a sidewalk for a week, and because the organs didn't actually shut down, they couldn't get the prosecution.
And I salute the intent behind the bill and the work that you've done on it, and I think that probably the vast number of cases that would come up, we would be in agreement, you know, as to whether or not it's a case that ought to be prosecuted. But I just I would like to stress that I think we need to make the language as tight as possible.
And again, I welcome that. My concern in terms of a process is, and this is not to Representative Hatfield, but generally, is that not only has this law been out there, but even the sub's been out there since February 13th, 12th or 13th. We're now at day 21, I believe it is, and we got to have crossover day by day 30. So while I'm happy to do that, if folks are ready to come with language today, that's what this committee process is for, and I would encourage anybody that has suggested changes to bring them forward.
Mr. Lunsford.
Thank you, Mr. Chairman. Just to the author, I do have a question on page 2, line 48. Why are we increasing the fine?
The only reason to increase the fines is that to me is to update it. As long as we're updating the code, it again to underscore the seriousness of the offense here. I will tell you that is one I have very little heartache over. If the committee sees fit to leave it in place, the object of this bill and the purpose of this bill is to be able to prosecute cases that we need to have prosecuted, and whether it's 15 or 20,000, I will tell you I don't have any heartache one way or the other over leaving it in place as 15.
Thank you, sir. That's my only question, Mr. Chairman.
See no further questions from the committee. Frank Mulcahy. Frank, you here? I'd like to make some comments. If you would make them brief. We did have some open testimony in the last meeting on this a couple weeks ago, so but we can make a few minutes for an old friend, that's for sure. And if you could pull the mic, one of them to you. Thank you.
Mr. Chairman, members of the committee, I will be very brief, and I'm only going to address the bill as it is, not the overall issue, because we do support the overall issue and appreciate Representative Levitas in bringing it. Our concerns, I guess, go along with what some of the committee members have with regard to the definition of the offense. I spoke with Representative Levitas before the committee meeting, and he assured me, as I always would expect, that if this bill goes forward, he'll be glad to work with us on language. I don't have language to present today, but our concern is that the neglect gets to be a little too broad when we're talking about a felony. I don't believe a felony, you would be charged with a felony if a doctor committed malpractice in surgery, but if a veterinarian committed negligence in operating on a dog or a cat, that could be criminal neglect under this statute. Those are the types of concerns we have, but again, we'll be glad to work on language with Representative Levitas or other members of the committee.
Thank you, Mr. Mulcahy. We appreciate it. I see no questions. Let me turn to the author, and the point's well taken that we are at day, 21 today. My sense is that we may have an adjustment in the schedule, though not a huge adjustment, but an adjustment nonetheless. I want to defer to the author on what he would like to do. We can go forward if he'd like to right now, or we can. I personally don't see any harm from a process standpoint in giving it one more hold to see what we can work out. That being said, I want to defer to the gentleman because it's his bill.
Mr. Chairman, as I said, I am happy to work with folks, and if we can get it back on a calendar within a day or two, that would be fine. Again,
we can.
My concern is this, and I guess this is really speaking more to the folks who want to participate in the process rather than the chair. But this bill's been out there a while. A lot of folks have had a lot of time to work on this. Mm-hmm. So if there is specific language that they want to come to, I would. A second time, if the chair would ask that question, I would say I'd like to go ahead and go forward. So with that, I'm happy if folks want to spend the next day crafting out language that they think would be helpful or narrowing it or tailoring it. Happy to do that, and we can just put it on the calendar for another day.
We can, and I want to be just crystal clear. I want to defer to the gentleman's wishes on this because it has been around for a couple of weeks, and if the gentleman wants to proceed and just let the process go forward, however it'll go, I will certainly defer to that and want to do that if that's what the gentleman wants to do. But I will tell you that from a process standpoint, we're not in a now or never posture. But again, I want to defer to the author.
Well, and I appreciate that. But what I would like to do is be able to bring as many people on board as possible.
Okay.
But I just want to do it within a very, very narrow time frame.
Okay. And it'll be back on an agenda for this week, for sure.
Thank you, Mr. Chairman.
If that's the case. But I would invite anybody who's got an interest in offering some tightening language to speak within the next couple of weeks privately with the author, and otherwise we'll go forward and let the process play out. Mr. Lunsford, did you have something else?
Mr. Chairman, if I could, for the author, and I'm not adverse to the idea of the bill, general concept, but as the author of this bill knows, I live out in the country. And people are notorious when they live in the city, like where you live, Mr. Levitas, when they want to get rid of an animal, they drive out through the country and drop them off. So they show up at your doorstep, and if you live on multi-acred property, and the best way to acquire a new animal you never wanted is to feed it, because it will stay. So what constitutes the ownership of the animal? So the animal shows up on my property. I don't feed it because I don't want it to stay. Have I now committed the act of cruelty under the page 3 of this bill? Or what if my kids go out there and feed it a biscuit, the dog stays around, but under line 45, I subjected the animal to neglect that resulted in death of the animal, but it was never really my animal.
I don't know under any construct of the bill what duty you or you via your children would have just as a result of having fed it a biscuit or even a meal. It's still there's no ownership that would transfer, and I'm not aware of any. And maybe again, if there's prosecutors out there, they can speak to this. That would transfer. Now, if you went down and adopted the dog, obviously,
right,
you'd have that issue. But I don't know. Again, if let's say, out in the city, we can't afford very nice cars. I go out to Henry County, I leave you my jalopy. Just because I leave it on your property doesn't make it yours.
If my kids would, that's part of the problem. But
and there's a lot of kids that could feed them a lot of food.
There is a lot of kids at my house, as the author knows. But I do have a question. Where are we talking about the ownership of the animal? And I'm sorry I got here late. We were in another meeting. Is it construed that it's the owner that committed the crime?
That would be the owner, the person charged with care for the crime. But again, I can't conceive of a scenario where a wandering dog becomes the property of the owner unless of the person onto whose property that dog roamed without some affirmative act by that person, more than just tossing out a dog biscuit.
Could I follow up, Mr. Chairman? and this is fun because this is one of the few times Levitas and I disagree. Say if the dog showed up at the house and we fed it for 2 or 3 weeks, have I now construed ownership under Georgia law? Is it now my dog?
The short answer to that is I don't know. Whether you've, yeah, common law dog maybe.
Common law dog. I like that. The dog's now eligible for paternal rights.
That's right.
I was just curious if we could get clarification on that. I'm not adverse to what you're doing, and I agree with what you're trying to do to keep people from torturing animals. But I do have some concerns that if one shows up you didn't ask for, when does it become yours?
Yeah,
We're still talking about dogs, right? Not children. Because again, with you, I'm always worried about
when
that.
children show up in my house I didn't ask for, my wife
This,
brought it.
discretion is the better part of valor, and my sense is that we'll hold the bill for a day or two. Let's see what we can come up with. I mean, the author's point is well taken in that you can't think of every what-if situation, and at some point, as with many issues that come before this committee, it does come down to discretion. It does come down to prosecutorial discretion, which I understand it can be comforting for some and perhaps discomforting for others. But I think we do better to take a day or two, see what we can, how we can tie in, and then march on from there. And we'll get it on an agenda this week without fail.
Thank you, Mr. Chairman.
All right, thank you, sir. Let me call, and I apologize for not doing this earlier. Let me. The plan is to have House Bill 31. Representative Loudermilk has been here before, including during the interim, to speak to that bill. Let's go ahead and call House Bill 31, and then we'll follow that with Representative Ramsey's bill. Chairman Ramsey, is that all right with you? Since Representative Loudermilk has been here before, and he's been working on this for the better part of his adult life. And, all right. Ms. Barnett is reminded me, and I apologize. I want to recognize the Judge of the Week, Judge Lawton Stevens. Are you here, Judge? There, just walked in the door. Under the category of timing is everything. Thank you for being here, Judge. We appreciate it very much. And Representative Loudermilk, let me ask you to continue. I think we have a substitute.
We do.
And let's make sure we have the right one. It's LC 342582S as in Sam. Is that right?
That's right.
Okay. And I know there have been some conversations between you and the Governor's Office of Highway Safety and the folks with the red light camera industry, for lack of a better term. And am I to understand that we have what is potentially a consensus substitute, or am I overstating that?
Well, I think we've got something that's workable here. We can move forward, and you're right. We've had so many revisions of this. In fact, there for a while I was thinking I've had as many revisions on this bill as Representative Leviticus has bills. But then I went and looked at his bills, and we're not even close. But we have worked really, really hard on this, and just to go over the changes that we've made, Mr. Chairman, it's best to kind of work in reverse on this. If you look at page 3 of the bill, what we're doing is making a change to the existing red light camera law. As you know, in the past hearings we've had, we've been around the block a few times on different issues, mainly dealing with the fact of putting the burden of proof on the shoulders of the accused versus the government bearing that burden. So what we've tried to come to is something that protects those who are owners of vehicles, but yet we're not the driver, to where they're not having to jump through so many hoops just to prove to the government that they were not the driver of the vehicle, that it was somebody else. And we've made some changes over time, but we found that there was a few other changes that need to be made. Lines 86 and 87 simply add that if the owner does one of the 4 items that you see through lines 88 through 94 or 96, we're adding a new line there. If they respond in one of those ways, then the ticket is dropped, basically. So the 4th item that we're adding there was in as a result of something I've testified to in this committee before, where a gentleman, and I've had several testimony from different funeral homes, to where quite often funeral homes were getting, the processions are being ticketed. In this particular instance, a funeral procession was in one of the cities, which is near my district. Someone who was out of state was in that procession. Their car got a ticket. They called the city. The city said, you have to come and bring an obituary. So they called the funeral home. The funeral home called the local municipal government, told them there was a funeral procession on that date, and they said that wasn't good enough, that the individual had to drive back in from out of state. They had to buy a newspaper, bring it to the city court, and show them a picture of the obituary. Of course, to the gentleman, it was more costly for him to take the day off and drive all the way back into Georgia and do this, but out of principle, he did that. And so we're adding this because that wasn't an isolated incident. I've received several phone calls and emails that this has happened in several different instances. So we're basically adding the fourth line that says if you were part of a funeral procession, then that you notify the court that you were in a funeral procession. If you were not the driver, you notify you weren't the driver with a notarized statement, and it's over. We're also adding, and again, this is we've worked together with the red light camera industry on this. If you look on page 2, and this is the reason I'm working backwards, I want to establish what we're doing. When you receive a red light camera ticket, that basically comes from one of the red light camera companies on behalf of the local court or municipality. What we're going to ask them to do is when that citation is received, you have the actual ticket, and then you have supporting documents that come with it, such as a photograph of the vehicle, etc. On one of those documents, we're going to have those 4 exceptions or those 4 rebuttable items listed to where the owner of the vehicle checks which applies, has it notarized, send it back in. And that's basically the gist of this bill. I'll be glad to answer any questions.
Let me ask a technical question, and Ms. Travis, this may be for you. I just wanted to make sure we're fortified on looking at lines 88 and 93. Are you striking sworn and leaving notarized in there? I just want to confirm that we're leaving the most the strongest impression on the credibility of that statement and the seriousness of it. What's your sense on that?
Notarized is just you're signing in front of a notary.
Right.
It's not a swearing. And swearing is only interestingly. I see. Yeah, you're right. It's on line 88. It's on line 93. And of course, left out of line 95. So if you wanted somebody to potentially be prosecuted for false statement or false swearing,
with the motivation and to the author that thank you, and to the author that if we're going to have someone sign said piece of paper and say this wasn't me, whatever context, I think my sense is that it's important for us to also convey the seriousness of doing that. It's not just some act that won't potentially have any negative consequences if it happens to be an untruthful or a false statement. What is your sense on that?
Well, this was just brought to my attention early on today, so I hadn't had a time to really dig into this. But the only question I may have for the legislative counsel or some of the learned attorneys in here on page 2, lines 59 through 61, we're adding at the bottom of those items a statement that gives what the penalty is for making a false statement. I don't know if that being on there would apply to notarized, or if that's one of the reasons legislative counsel removed the word sworn, is that it was consistent. This is a question, not a statement. So I don't know if because of that on there that the notarized carries the same weight, or if there is a particular reason that there's a linkage between those.
And just to make sure I'm clear from a penalty standpoint, Ms. Travis, if you know and if you don't know off the top of your head, that's fine. You sign a statement. You notarize something. You sign something that's been notarized by a notary public. The ramifications of having that, if that statement ends up being false, what are the ramifications of that? Just to make sure that we're clear on that. From a false swearing standpoint, if it even rises to that level.
swearing carries 1 to 5.
And that would occur if a statement that's been submitted and notarized is proven to be false. Would the false swearing statute kick in at that point? That's really, I guess, the heart of my question.
The crime itself says a person with whom a lawful oath or affirmation has been administered, or who executes a document knowing that it purports to be an acknowledgement of a lawful oath or affirmation, commits the offense of false swearing when in matter or thing other than a judicial proceeding he knowingly and willfully makes a false statement. So it's pretty clear to me that you actually do need to have some kind of oath in order to oath or affirmation in order to violate false swearing.
And so would a statement that's been notarized rise to that level, or would it need to be a sworn affidavit in order to rise to that level?
I think it needs to be sworn.
We'll get some feedback, I know, from members of the committee, but I just want to put that out there to make sure
Again, Mr. Chairman,
we're
this is-
aligned with where we want to go on that
Right.
philosophically.
With that statement, we're not adding any penalties. We're just advising
Right.
for what's already that she's
Right.
read the statute.
Just want to make sure the form we've got in is proper. Mr. Thompson, did you?
Mr. Chairman, it actually goes to the same matter.
Okay.
I think by taking the word sworn out, I mean, when you notarize a document, I think you're simply stating that's the person that signed that is the actual person.
Right.
I think that's what the notarization is. And so I think if you take the word sworn out, they haven't committed the crime of false swearing at that point. And so
That was my sense,
think
but
we're defeating
it's always good to vet it out. Thank you for making me feel better about my comment. Mr. Franklin.
Thank you. Now, the few documents I've had notarized were the notary signs. The notary saying that this was sworn before the notary, and it's sworn. It uses that word, and I think Representative Loudermilk allayed my fears with the language on line 59 to 61, where the ticket coming from the red light camera companies say that the statement shall also contain a provision notifying the recipient of the citation that knowingly and willfully making a false statement is a crime punishable as provided in Code Section 161071. So it seems that since you are swearing before the notary, and with this language, that should allay our fears.
And I understand the notice provision as it relates, they're giving you that notice in line 59 to 61. I just want to make sure that the notarized signature rises to that level. That goes my question to Ms. Travis before, and let me ask you to.
There's another crime of false statements, which is 161020.
Mm-hmm.
And that's exactly what the reference is supposed to be. A person knowingly and willfully falsifies, conceals, or covers up any trick, scheme, or device, a material fact, makes a false, fictitious, or fraudulent statement or representation, or makes or uses any false writing or document knowing the same to contain any false statement or entry within the jurisdiction of any department or agency of state government or of the government of any county, city, political subdivision shall, and it carries the 1 to 5, and I'm assuming that this is going to go to state government because it's ticket jurisdiction. I know the prosecutors are here, but this code section, if you didn't want to have the swearing in, doesn't require a swearing in, it's making a false statement in a government document. So that might be another angle.
I think those may be two different things.
They are.
Yeah, I mean, I don't know that really. Yeah, I don't think that those are in alignment. Personally, Mr. Levitas.
And I'm glad that Representative Loudermilk is seated for this one, because this may be an area where we actually agree on. I mean, what we're talking about, and you know my opposition to removing the red light cameras, but I would be personally uncomfortable if we didn't actually make it 161020. I don't see taking a red light violation, even if somebody provides false testimony with regard to that, and turning it into a 1 to 5 felony for that. It would seem to me that we're better off with 161020 under false statements. I mean, you're still able to go to jail for 12 months for that. You still got a misdemeanor, a crime of moral turpitude. That's going to be pretty bad on your record. And my suggestion in that regard would be to do 161020. Because it does go not just to the state, but it goes to any county, city, or other political subdivision of the state. So it would certainly apply to any court that has jurisdiction over the offense. I do, Mr. Chairman, and when we get to that the other parts of the bill, I do have another question about it. I don't know if now's the appropriate time, or you just want to finish fleshing this particular point out.
Let me go around the table and we'll come back. Ms. Abrams.
I guess I have two questions, or a question and I think I'm correct on this. I believe that when you're swearing before a notary, the swearing before a notary only attests to your identity. They are not swearing to the validity of what you're saying, and so you're swearing that you're the person signing. That's why we have to get all of our documents notarized, that we are the person who actually comes down and gets it signed. So I don't think that would. I would argue that doesn't fit neatly into that language. My second question, though, to Ms. Travis is with 161020. Is the making of a false statement, how do you prove that the statement was intended to be false? Is it simply the fact that they did have it notarized? I mean, what are the standards for proving that they violated 161020?
I didn't bring an annotated version, so I could look at some case law.
Okay, thank you.
That does carry over 5 as well.
Okay, thank you.
Mrs. Cooper.
Thank you, Mr. Chairman. Somebody said this bill's been around a long time, and I guess I missed the subcommittee hearings about it. But it seems like to me that basically, since courts are really busy, I mean, who's going to get prosecuted for false statements? I mean, they're just going to accept it. It seems like to me, especially lines 88 through 96, we're just gutting the whole red light law, and people might as well just not have the red lights because people are going to sign the statement and get out of it because the courts don't have the ability to follow up on whether they're false statements or not. I mean, I'm asking. It seems to me that this just guts it. The whole process for having them.
Do you want to address that, or
is there anybody else that is in favor of them that might know about it, or anything that you might ask?
Well, I may add, Mr. Chairman, that, and Ms. Cooper, that I've worked closely with this language on red light camera industry and the Georgia Municipal Association. They're comfortable with this language. I think this is a good balance in protecting the rights of owners who have had to go to their own expense and to their own trouble to prove that they weren't the driver of the vehicle. I mean, there's numerous instances I could go through, from somebody left their car at a maintenance shop to where they were test driving it, and they went through the red light camera, and he's had to take time. I think this strikes a good balance in there to give the owners who were not drivers the ability, without having to jump through so many hoops, to prove their innocence. I've brought up the same concerns that you did in a meeting we had recently about this. Is we don't want to set up a situation to where someone can be an habitual abuser and just always sign the notification and send it in. And I was advised by those that we're working with that there's already laws in place that would give the municipalities or the local governments the ability, based on, you got somebody who once a week just signs a statement that they're not the driver of the vehicle, that there would be the ability for them to then, based on the evidence, further investigate what they're doing.
Mr. Chairman, may I?
Sure.
Thank you. You know, under number 1 under there, I can see it. If you have to go into court and say that it wasn't you, that puts a. I mean, it's a little harder, I think, for people to, swear to a false statement in court. But when you put it just a notarized statement, here again, all that is your signature. And, Mr. Chairman, if there's somebody from the municipalities or the people who prosecute these people that might be able to validate that this is workable too, and they still think it's worth having the red lights, would it be possible for them to speak?
We don't actually have anyone signed up other than Mr. Dallas with the Governor's Office of Highway Safety, and we'll hear from him as soon as we go through this round.
Thank you.
Mr. Setzler.
Thank you, Mr. Chairman. To the author, I just wanted to get the author's take on this conversation about sworn versus otherwise. Is this a... Let me restate what I think the author's intent is here. I'm understanding that the 59 through 61 reference, making it clear to people that a false statement is punishable by a crime. The intent there is that even without a sworn statement, even with a notarized statement that they've made, that they recognize that the effect of making the statement is still punishable by crime. Whether it's a sworn act or not, said statement would still be subject to criminal law and prosecutable. whether or not it's sworn or not. Is that your intent?
Correct. And right now, this is not changing anything existing law. If you were to make a false statement right now, and I may bring up from the previous questions we had, 88 through 94 is existing language. Right now, as the way the red light cameras law is written, you can send in a notarized statement to the court. The only difference is that the court, may determine whether it's rebuttable or not. And we've had instances where the courts have just said, "Well, we're not going to accept it." And all this is just saying, "Hey, if the owner sends it in, that's rebuttable if they've made the notarized statement." So we're not changing anything there. But I do agree with Representative Levitas there that I think I like the idea of tagging it to 1620 because, again, we're talking that this is a civil issue, and then to take a civil to a felony, I think, is overbearing because, and quite honestly, there could be some mistakes made by some that was like, yeah, my brother-in-law was driving the car that day, and then it turns out, oh, shoot, I forgot, that was me. I think that we always have to look on the benefit of the rights of the citizen. And I think there should be some penalty in there for making false statements, but I would agree that I think the 16-10-20 would be more reasonable.
So just for purposes of clarity, what the framework you're trying to create here is that an individual can designate in writing, make a statement in writing that's still notarized. It's not in the framework of a sworn statement, but it still has the effect of being able to be prosecuted under criminal law as a misdemeanor. So if said statement's not accurate, there's still a means through criminal law to prosecute somebody who's trying to Chairman Cooper's concern, treat this as kind of not a very substantial set of circumstances that they've got to sign the statement. I think Chairman Cooper's concerned that the whole we make a mockery of the system because someone can just sign false statements easily and then pass them on with really no consequence. I'm hearing from you it's your intent to make sure they're still subject to criminal treatments, albeit a misdemeanor, in a way that can be done subject to a notary as opposed to coming down to the courthouse and that kind of. Is that in essence your public policy?
Exactly right. And the way we got to this was really sitting around the table with the red light camera proponents, the industry, the municipalities, and coming up with actually this language that is here is that we want to protect the owner, but yet we need to let them know that if you are making a false statement, there is already existing criminal penalties in the state, and we just want to notify them. A shot across the bow, say, hey, if you send this in and it's false, you could be prosecuted.
And I think what we need to do is to get some clarity on exactly what the intent is with regard to what the consequences of that false statement are. As I understand it, just to make sure the committee's clear, as I understand 161071, that rises to the level of a felony. Is that right, Ms. Travis? And so does 161020. Is that your understanding, Mr. Levitas? Or, I'm not doubting you, Ms. Travis. I'm just making sure we're all on the same page here. And to the author, if that in fact is the case, if we have that kind of false statement, my sense is that might be a bazooka going after a fly.
Well, so I guess my question, Mr. Chairman, is what would be the penalty now, even if we didn't place this statement on the ticket itself? Because as of now, you can send a notarized. You just have to write it yourself. Well, the only thing we're doing is putting it on the document, so it's from my perspective in representing the innocent, the owners, is to make it easy for them from the red light camera proponent side, making sure the language that's used is precise. And so there's a balance there.
Sure.
But right now you can write a statement, have it notarized, send it in to the courts, and the courts often will accept it. I guess my question would be, what would be the penalty right now, even though we're not citing it in code? What would be the penalty today?
Ms. Travis, do you have a thought on that? So really, the effect in terms of, are you saying that the effect in terms of how it will be treated right now is there's no change? It's the same. I just want to make sure we're clear on that.
By having, it does say it's a sworn statement, I think you could be prosecuted.
Okay. I just want to make sure that we're clear on exactly what the change would be in policy, if any, but as I hear it, there really isn't. Is that true? Hold on one second. So there would be no change in terms of the treatment of that kind of act right now. Is that true?
Under current law, not anything to do
And assuming that a notarized statement rises at that same level of conduct, or does it?
I don't think it's the notarized part of it is whether you just sign your name and it's notarized. The notary is just an assurance that it's you.
Right.
It's the swearing that raises it.
Mr. Chairman.
I understand, and I just want to make sure that we're all clear on that, so that really goes back to the issue of notarized versus sworn. Correct?
Not really. I mean, you could have just a sworn statement that's not notarized. The notary doesn't really add any extra flavor to it.
Right. Okay.
Mr. Chairman, can a notary legally take a sworn statement from somebody in Georgia?
The notary is assuring that the person that's signing it is the person that says that I say I'm Jill Travis. The notary either knows me or sees my license and says that is Jill Travis. That's all the notary does.
Does it have the effect of a sworn statement in a general context in Georgia? If I have to go to a notary and say I'm making a sworn statement and sign, does that exist anywhere? Okay.
Not by virtue of just being a notary.
Okay.
If there's a swearing in the document itself or some kind of assurance in the document that the above is true and correct to the best of my knowledge, then that's the swearing. But
Okay.
the notary seeing you sign it or assuring that it's you is a different matter.
So you're saying it could be looser than a notary. You wouldn't even need to have a notary to make a sworn written statement.
Correct.
Does that hold up in a judicial context if someone makes a sworn statement? Let's say that out of an abundance of caution, someone goes and has a notary designate that they were the one that made the statement at such time, and it was notarized. Not that the notary would have to be there, but the person made a sworn statement. Would that sworn statement hold up in court as a sworn statement? I mean, or does someone have to swear in the presence of some magistrate somewhere?
You can swear that it's true and correct without being before an official.
Okay.
I mean, when you send in your campaign disclosure report, you swear that it's correct.
Mr. Thompson.
Mr. Chairman, I guess to just add to what we're saying, I would point out, number one, we are changing current language. The current language requires a sworn notarized statement. And this amendment as proposed, or this bill as proposed, would take out the word sworn. I think the word sworn needs to be in there because a notary, it just goes to the discussion we just had. And I'll give you an example. When you go to a closing, you sign a deed, it has to be notarized to be recorded. There's no particular sworn statement in a deed. You're notarizing it to prove that that's the person who signed it. You sign an affidavit at that closing, you're swearing that fact is true and correct. There's an actual oath within the affidavit that says this is true and correct. So I think a sworn notarized statement is something different than a notarized statement. And I think it's important in this particular statute.
Thank you.
Thank you.
Mr. Levitas.
Thank you, Mr. Chairman. One of the things I thought we might be able to do is, and I'm a little bit reluctant to suggest this, but if we put on subsection B under false swearing or under false statements, whatever you decided, something to the effect of provided, however, that a violation of subsection A, which is the false swearing, based on an affidavit submitted pursuant to, and we'd have to have the right language, but 40-6-20, whatever the right code section is, shall be punished as for a misdemeanor. That would, you'd still capture the false swearing. You would just, in that particular instance, when you're talking about a civil violation versus something else, and for that particular code, you would have it as a misdemeanor, and we just carve out a little exception. Because the only other way I could think to do this, the only other even closely related criminal statute that I can think of is false name, but that's really where you're trying to hide your true identity, and you may be not trying to say you're not Representative Levitas, you're just saying Representative Levitas wasn't the guy driving the car. But perhaps a simple carve-out would take care of it, and just say when you're talking about an affidavit submitted to this code section, it should be punished as a misdemeanor.
Let me ask the author his reaction to that.
I would be willing to do that.
My sense is that that's coming as an amendment in a little bit.
Yeah, I would not be opposed to that. And let me clarify, too, that I'm not opposed to the word sworn. In fact, I think that was I'm not sure that was brought to my attention that was made by legislative counsel. So if working with the term sworn with Representative Levitas's proposed amendment would satisfy the committee, I'd be willing to go that route.
Ms. Banfield.
I'm just trying to understand. I'm looking on page 2, line 61. where it talks about punishable as providing code section 16-10-71. Is that punishable as a misdemeanor? I mean, no, that's punishable as a felony. 1620 is also punishable as a felony. I think this is getting more confusing.
Ms. Abrams?
I'll wait for now.
No, I've got someone. Do you have a question? Yeah. Mr. Sessler.
To the author, I just wanted to kind of regroup on the conversation. We've kicked around the idea of sworn statements quite a bit. I think to satisfy some concerns, is it? And I heard you said you'd be satisfied with sworn being in there. Is it? Would it be the author's intent for a friendly amendment at some point? I just want to kind of summarize where we are. Would it be considered a friendly amendment if sworn were put back in? What other changes would you anticipate would be needed if that were put back in to make it all consistent?
Yeah, I don't know that it wouldn't have. It's really the statement I made earlier was a question to the committee, because when it was brought to my attention that the sworn was taken out during the legislative council process from the meeting we had with them the other day, and I assumed that it was struck to be consistent with what's on lines 59, 60, and 61 on page 2. That was my assumption, because we just picked this up. I just got it this morning from the changes that we have made late last week. So as far as the sworn being in there, I think it would be consistent. I would like to go down the path that Representative Levitas is that if we could make this a misdemeanor, even though currently right now it would be a felony to do the similar type thing, I think it would be more clear if we state something like that it would be a further misdemeanor in making a false statement. But I don't have a problem with the sworn being in there, and like I said, that wasn't the intention originally to have it stripped out. I just assumed it was making it consistent with something already in law.
Let me ask you, Mr. Loudermilk, would we do well to hold it for a day or two? I know we've had it for a while. I know we've gone through several iterations, a lot of negotiations on it, good arguments on both sides. Do we do well to go ahead and take an extra day and just make sure we're wired tight on?
I'll leave that to the judgment of the chair. I'm willing to come back and do this further.
Again,
I just want to make sure we get it right.
Just out of an abundance of caution, I think I'd like to go ahead and do that, just to make sure that we've got the language correct. That is not a means for delay. If it were, we wouldn't be here to begin with.
Right. I understand.
So I would feel better if we went ahead and had real clarity. And my suggestion would be that we always seem to have a tighter ship, and this is not by way of commentary about anyone. But I would definitely consult both with the originating legislative council on this as well as Ms. Travis, just to make sure that the council and you, and therefore the committee, will end up being on the same page as to exactly what we've got in terms of penalties as it relates to the false swearing. And I say that in a general term.
Yeah.
Okay? I think we just do well to do that. Would that be all right with you?
That would work fine.
Okay.
Thank you, Mr. Chairman.
And we'll definitely come back. Yep.
Can I just throw out a suggestion? This is the concern I have is
Sure.
I just want to make sure I fully understand the consequences, and I think it is wise to wait a day or two and just make sure we look into this. I'd like to know if you lie in court or make a false statement in court on any other offense. My understanding is that is a felony. So why carve out a special exception here? If you're lying about, I don't know what other offenses are prosecuted in municipal court, but some other offense in municipal court, public drunkenness or something. So why is this treated differently? All other offenses of false statements and false swearing are treated as felonies in municipal court or state court or superior court. So that's the concern is I don't want to create this hodgepodge where we have a special exception just here. I want to make sure I understand that.
My sense of this, and I'll defer to the author on it, it's his bill. My sense of it is that some on the committee may be looking at it in that context, because we are ultimately in a civil context here still, are we not? As opposed to a criminal context, right?
That's correct.
And so I think that may be the origin of perhaps some discomfort on the part of some as to the penalty provision for the false statement. But that's simply a guess on my part.
But this falls in the same line, Mr. Chairman, as a parking violation, and that's kind of where I'm going with Representative Levitas. Is it would be shameful to spend 1 to 5 years in prison because of saying that I didn't park the car there, someone else did. When
But, you know, if you make a false statement in civil court, well, I mean, that's just treated as a felony, swearing a divorce, false swearing in a divorce or any other civil proceeding. So I just want to be cautious about why are we treating this differently from any other false statement.
And now,
I think
my response will be
lying
that's a matter of
blind is
policy. It's a matter of policy, and how do we, as a matter of policy, how does the committee feel about this particular infraction on this in this particular area, and how does it want to be treated? And does it make a delineation between the two? Not, I certainly will not seek to persuade or dissuade, but I think it's just a straight-up matter of policy, how you want to treat it.
And
Me and Mrs. Cooper first, and then.
Thank you, Mr. Chairman. And I sort of with Representative Benefield. The other aspect of that too is, if we're going to make it easy for them to send back in a paper that they don't have to appear at court and they're in a funeral procession and all, we're going to make it easy. What I think is that it carries some weight to know some people just might shrug off a misdemeanor, but if you know by false swearing that it's a felony, you're not near as likely to do it. And so we're bending a long way by letting them have a checkoff list. It just seems like to me that the teeth is there, is that if you falsely swear, you could face a felony. And I have problems with that.
And as always with this committee, what we end up doing is we end up having these debates, and we are able to distill the issue that's left. And what I'd ask the author is, he's heard what he's heard, and I'm going to, the vice chair will have the last word in just a minute. We've distilled it down to really what that penalty provision is going to be. I would ask him to think about where he wants to go on that, and as a matter of policy, I think he's heard where some folks are, on the committee are and where they're not, and how he wants to approach that. But I think you've heard some good back and forth on that may ultimately help the final product. Mr. Vice Chairman.
Thank you, Mr. Chairman. I think that a lot of the issues that we're having and problems we're having in reconciling how to deal with this as opposed to any other case where someone would provide false testimony in a judicial proceeding. It's emblematic of a larger problem we have in this area, and that is you're requiring people to come in and defend against a camera. It's a situation where they cannot confront the witness against them, and this is something we've talked about in Transportation Committee before and even on the floor of the House. But I think it goes back to, or at least I go back to, the conclusion that these cameras are really not in the best interests of citizens of Georgia. And while I know that the thrust of the bill is not towards just elimination of the cameras, that's certainly the direction I would, as the author knows, I would prefer to see us go in allowing citizens to be able to confront their accusers. And but having said that, I'm supportive of the bill. I think that there is some rationale for saying that you would treat this as a misdemeanor if someone submitted something that was false, given that it starts out in a civil context, Mr. Chairman. But I would, of course, defer to the author to make the decision that he feels like would be best in this instance.
And that's where we are. We are in a place where there are some in the committee who may feel that there's no distinction, and there are some who feel that there probably are, and it's just a question of what approach the author wants to take. And I think maybe taking a day or two to digest that and take the collective pulse on that might be a good idea and help the bill ultimately. So we appreciate your patience on that, but I think it's a good conversation.
All right. Thank you.
Thank you. Mr. Ramsey. We'll call House Bill 1121. Mr. Ramsey, if you wanted, you could do it from your chair there, or you could do it there. Okay, whatever works for you. Mr. Dallas, you look downright disappointed. My sense is that you'll have your opportunity. Chairman Ramsey, thank you for bringing this bill, and you have the floor.
Thank you, Mr. Chairman. I want to quickly introduce who's joining me up here. This is Dr. Eric Weirn. Did I pronounce your name right? He's the Deputy Director with the Governor's Office of Student Achievement. And given the factual context in which we bring this bill forward, we thought it would be a really good idea for him to be here. He is, along with the director of that office, have been overseeing the audits of state standardized tests that last year led to an investigation and a couple of convictions ultimately of school officials that had engaged in test tampering, and have also overseen the most recent audit that has raised red flags in well over 100 schools of potential testing irregularities. And I want to make I want to be clear right off the bat. I mean, there's been a lot in the news lately about the results of that second audit that I think the number was 150 schools that had, over 150 schools that had red flags raised for potential testing irregularities. There has been no allegations of cheating. That is simply a trigger based on statistical analysis that the folks that conduct this do it all over the country, that potentially raises a red flag that says you guys need to investigate this. There could potentially be been some tampering that has gone on here. And in fact, it's the same process they went through last year that resulted in those couple of instances in DeKalb County that we all read about in the newspaper. This bill really is about one thing only. It's ensuring the integrity of our state's standardized testing system to ensure that parents and students alike are confident in the feedback and the knowledge they're gaining from the results of these tests. They should be able to know if their child deems to have made adequate yearly progress on these tests, that they're keeping up with their contemporaries. Conversely, students and parents should also be given the opportunity, if they're not keeping up, if they didn't meet AYP, that student and those parents and those school officials should be given that knowledge and that test result, so they'll know to bring resources to bear to help that child, that student, get caught up with their classmates. I'm going to quickly go over what the bill does. I think it's pretty straightforward from a understanding what we're doing here, and then I'm going to get in a little bit more in depth into the why behind the bill. Simply put, what the bill does is it makes it unlawful for anyone to knowingly and willfully tamper with or facilitate cheating on tests required by the State Department of Education. It also provides for an it provides for the Governor's Office of Student Achievement to provide for annual guidelines to examine the results of the mandated tests. So we have this every year going through this statistical analysis, so we're seeing or identifying potential red flags, and also so we can bring to light schools and school systems that we may need to investigate. It also provides for the penalties for violating this. In the criminal context, it creates a misdemeanor under state law with a potential $1,000 fine and up to 30 days in jail. It also requires that the Professional Standards Commission either move to suspend or revoke an individual that has been found to have committed one of these violations. Now, right now, the PSC has that authority, and in fact, the individuals that were found to have done this last year had their license suspended for a time. All this says is that you are required to either suspend or revoke if you find an individual, a school official, has committed one of these acts. Now, I think the why is the most important here. And I've heard a lot. There's been, if you guys have been reading the newspaper, you know there's been a lot said about this in recent days by members of this body, by members of the school committee, community, parents, teachers alike. And one of the things I've heard over and over again is well, the punishment doesn't fit the crime. Well, I would tell you we have a very, very, very unusual situation right now in terms of the inconsistency our current status quo in law has in terms of dealing with these kind of situations. Last year, in last year's audit and subsequent charges that were brought that to light. Under current state law, this is not an offense to do this. Specifically, there's not a specifically enumerated charge for willfully or knowingly tampering with tests. But there is a law, it's a felony, that prohibits altering a state document. So you have this, and that's a felony, 1 to 5 years. And I think in talking to, in looking at our criminal code and talking to a number of members of this body, that this offense, while egregious as a parent, if this happened to my child, it's egregious. But in terms of looking at the acts that constitute felonies versus misdemeanors in our state's criminal code, this probably shouldn't be a felony. And right now, without this specific enumerated offense, if a district attorney wants to charge, that they have this one option, altering a state document. But here's the problem. If they bring that charge, or if they bring that charge, it's a felony only. That's their option. And you have a situation where if you the elements of that crime, if you physically change the answers on a test key, you can be charged with altering a state document, and you are then subject to being prosecuted as a felony. If you are sitting there in the same room with that person, and you're reading the answers to them, the correct answers, and the other person is erasing and putting the correct answers in, that person can't be charged with altering a state document because they're not physically doing the altering. So you have this kind of bizarre inconsistency in the law that says we can charge some violators as felons, but some that are engaging in almost exactly the same conduct, particularly in terms of the results, can't be charged with a crime. So I've had several discussions. Actually, I've had several discussions with the district attorney in DeKalb County that brought these charges. And one of the questions I asked, well, if you would have had this option of charging under this specific enumerated offense, is that something you would have pursued in lieu of this altering state documents charge? And he said, yeah, probably so, because it's something that is specifically tailored to get at the conduct that we're trying to get at, as opposed to having to search around the criminal code to find something to shoehorn this into a criminal context. So I think in terms of making our state law consistent, I think this is certainly a good step in that direction. I've also heard that, well, what about job loss? Isn't that enough? Isn't that enough of a deterrent? Well, I've got two answers to that. One, every single teacher and school official signs a code of conduct. And last year, despite that, several school officials, I think it was a principal and an assistant principal, were found to have done this. They knew that they could lose their jobs. We've just had, and again, this is not allegations, I'm not making an allegation of cheating, but we've just had over 150 schools flagged for potential testing irregularities. I think it's reasonable to assume that out of those investigations, there's going to be some individuals that were found to have engaged in this behavior. And you can't tell me that every single one of those people that have done this previously or have potentially have done it on this round of audits didn't know if they were caught for changing the documents, they wouldn't lose their job. I don't think it's an effective deterrent. Not to mention, just in terms of the punishment actually fitting the crime, this is a situation where you as a school official, a person that is entrusted with educating, or we're sending our children, I have a student in the public school system. If you do this, you are denying that student and those parents the knowledge. You're giving those parents the false sense of security that your son or daughter is keeping up. You're denying that student the ability to know that they need to get some additional tutoring. They need to get some help. And if you're doing it on an entire school level, you are potentially denying that entire school the additional tutoring that comes with failing to meet adequate yearly progress. The federal requirement under No Child Left Behind that additional tutoring be brought to bear, or you have a parent, if a school system fails it over a number of years, the parents have the right to take that child out of that school and send them to another performing school, and you're potentially denying parents those options when you commit what I think is tantamount to a fraud. You're defrauding the child of an education. You're defrauding the parents of the knowledge that they need to bring some additional resources to bear with respect to their child. I think another question that may arise, and then I'm going to close and ask Eric to add any comments that he may want to. But right now under current law, the PSC the Professional Standards Commission, they have the ability to investigate instances of school official misconduct. They have it is within their power to suspend or revoke an individual's license that's found to have violated this. I've heard questions, well, why aren't you providing for in the bill an appeals process or due process? I've seen that email going around. We're not doing anything at all in terms of the process that already exists in state law that the PSC goes through when there's been an allegation of misconduct by a school official. So I think by providing an additional process for these specific types of violations is absolutely unnecessary, because that already exists within the framework of the PSC's existing authority in terms of monitoring the conduct of school officials. I would also add, Ms. Abrams left the room. She is going to offer an amendment that I think is a good clarifying amendment. I'll let her speak to the intent and the contents of it. But as the author of the bill, we will ultimately accept that from our perspective, if it's the will of the committee, as a friendly amendment and one that we believe makes sense. So with that, Mr. Chairman, I will ask if my counterpart up here wants to add anything, and then we'll be happy to take as many questions as the committee wants to ask.
Yeah, I'd just clarify 2 points.
Could you please identify yourself again?
Sure. My name is Eric Warren. I'm the Deputy Director at the Governor's Office of Student Achievement.
Thank you.
Right. One is that the statistical guidelines as they're outlined in the bill, and as is the case in the audit that's going on right now, are only meant to kind of serve as a trigger to where we might look for testing irregularities. The statistics tell where an investigation might need to be done to examine whether something inappropriate occurred. The numbers by themselves won't determine whether someone knowingly or willfully changed answers. And the other thing I'd say is to underscore a point that Representative Ramsey made well, which is that the real harm done in this is to the students who are affected by having their results altered, in that under No Child Left Behind, if a school doesn't make its performance targets every year, those kids are eligible for extra tutoring or school choice or other things, as depending on where their school falls in that process. So if a school makes adequate year-level progress inappropriately, then those kids are harmed by not receiving those services that they otherwise would have.
Mr. Vice Chair.
Thank you, Mr. Chairman. Representative Ramsey, is it the intention of the administration to prosecute school children under this legislation?
No.
Well, I ask you that because if you look at line 19 on page 1, it says, "It shall be unlawful for anyone to knowingly and willfully do any of the following acts." Then you go over to page 2, lines 27 and 28. Line 27, subsection 5 says, "Fail to follow test security protocols before, during, or after test administration," or subsection 6, "participate in, direct, aid, counsel, assist in, encourage, or fail to report any of the acts prohibited by this subsection." It's pretty clear to me from reading that language that the child who would actually participate in any act of cheating on a test that was covered by this would be subject to prosecution.
Vice Chairman, it's a fair point. If in line number 19 you want to, if we can come up with language to clarify that it's limited to the individuals charged with administering the test, not the actual takers of the test, the school officials, the cheaters, the administrators of the schools.
Right.
That was a slip.
Wow. It's kind of a big one, but
the individuals charged with administering
right.
the test is who we're trying to get at, and if you
so we need to change anyone.
Yeah, and if we want to think about it for a second,
okay.
To encompass all school officials charged with administering the test, that's what we're trying to get at.
Okay.
So.
Mr. Everson.
Thank you, Mr. Chairman. Representative Ramsey for this legislation. page 2, line 42, and I just want to get some clarification on this. The Public Standard Commission, at what point will the Attorney General be called into a situation?
Well, you really have that. There's kind of a two tracks. You have the criminal track, which the Attorney General would be charged with. If you're going to charge somebody with a criminal misdemeanor under the law, that would be within the bailiwick of the Attorney General. If when you talk about a licensure for a school official through the PSC, that's within the PSC's jurisdiction. So when you're talking about, I think when you're talking about bringing charges, which are available under this for the criminal misdemeanor that we'd be creating, that would be the Attorney General.
Okay, so the PSC will conduct an investigation as far as
the PSC's role is to ensure is to ensure that the individuals under its jurisdiction are conducting themselves professionally. That's the name of the.
And based upon their findings, they will report this information to.
Well, they're not reporting it to anybody. What they will do, what I think the process that will unfold is the school system itself first will likely conduct an investigation when a statistical anomaly is identified. When you have a red flag that's raised to the statistical analysis of the testing process, then if the school system finds there's been violations, much like occurred in DeKalb County when it was turned over to the local DA, they would then turn that information over to two sources. They would turn it over to the PSC, who has the ability to mete out penalties with respect to that individual licensee's license through suspension or revocation. And then the Attorney General of Georgia would have the ability to bring criminal charges against individual violators.
Okay, so at no point the governor can authorize the Attorney General or ask the Attorney General to look into these allegations?
I think that the governor can ask the Attorney General to do anything anytime,
right.
But this is just vesting with the Attorney General the ability to investigate and bring charges.
Okay, thank you.
Ms. Benfield.
Thank you. My question's dealing with the same subsection with the Attorney General. It's two parts. One is why the Attorney General, not the local district attorney, and two, has the Attorney General's office been consulted on this? And if so, are they supportive of being the ones to investigate these allegations?
I think there's been a good deal of discussion, and it might be helpful to ask Nels Peterson, the governor's executive counsel, to come forward also. He's been involved in a lot of the preliminary work on this and speak to that. But I think there's a general sense that from an independence standpoint, given that we're talking about district attorneys that are in the same community wherein these violations have occurred, we felt like it might make more sense to have the Attorney General vested with this authority, so you have a little bit more independence out of that community in terms of bringing charges against potential violators. I'll ask if Mr. Peterson wants to come forward and grab a chair and get in the hot seat. Maybe he can add a little bit more color to my answer.
I think it's fair to say the Attorney General's office is aware of the bill. We've not asked them to take a formal position on it, and obviously they're not here, and I don't want to put words in their mouth. But I think our view was that it was appropriate to, in these circumstances, have someone from outside the community who is empowered to investigate it as appropriate.
If I can just follow up, the reason I'm raising this is I've seen over the past few years that the Attorney General's office is often charged with investigating various issues, and I'll pick up the phone and call usually Mary Beth Westmoreland, who's usually the one here, and just say, hey, are you aware of this, and are you all equipped to investigate? And quite frequently the answer is no, we don't have the resources to investigate. So I just want to make sure if this does move through the process that they are that they have the resources to investigate. And I don't know how you figure out how much it's going to cost or how many of these allegations. I just want to make sure that they're supportive of that, because I have had several conversations with them on other bills where they did not want to be charged with investigating certain issues because they just simply didn't have the resources.
If I may, to that point, PSC will be the state investigative entity doing the initial investigation in these areas, and it will be only after the PSC has reached a certain level of comfort, a certain conclusion that the AG would become involved in this. I'm sure the Attorney General's office would take the position that they need additional resources to do an investigation, but I don't know that that would really distinguish them from any other state agency given the budget situation we're in. So.
Ms. Abdul Salam.
Thank you. Thank you so much. Representative Ramsey, my question actually starts over on the summary, about midway of the summary page. It talks about the bill providing exceptions, so there's no violation if information has been made available publicly by authorized personnel. And I just want to be clear, where is that referred to in the legislation? Is that on line 30, where it talks about that? And what other exceptions would be made?
I mean, that's the exception. Are you looking for additional exceptions? But
no, I mean, it's not clear to me when it says if it's made public by authorized personnel, but it doesn't really talk about who the authorized personnel is and what do you mean by making public, and what can they make public? Can they make the test public?
I think that's part of existing test protocols that are already established and currently existing within the within the jurisdiction and the authority of the governor or the Office of Student Achievement.
Well, it says this bill, so I'm looking for it in the bill.
I'm not sure I understand your question.
This bill provides exceptions, so I'm looking for the exceptions in the bill.
And that's the exception. It's the subsection shall not apply to the public release of any assessment or portion thereof by any person authorized to make such release.
Oh, I asked you that.
And the authorization, right, and the authorization exists within current test protocols that are already provided for in state law and regulation.
So that is the exception.
Yes, ma'am.
Lines 30 and 31. Okay.
Yes, ma'am.
And then the other question that I had was, sometimes things are leaked, and we don't know who actually released it. What would happen in that instance?
What do you mean if somebody leaked what?
Whatever you're covering in this section on line 30 and 31. Because I'm still not clear. If that information is released publicly.
I think if somebody that was not authorized to release the information was found to have, they could potentially be in violation of this this new law. Whereas if you're authorized, you're covered by the exception.
Okay. And you said the definition of the authorized persons are listed someplace else.
Well, I can speak to that a little bit. The actual contract is between the testing company and the Department of Education. So they have a protocol by which they release old forms of the test and some items every year. So they're the DOE is the one who handles that.
Okay, so it's not actually in this bill. It's not any additions or anything in this bill.
No, we're not setting out who's authorized and not authorized to release information.
Thank you.
Mr. Setzler.
Thank you, Mr. Chairman. To the author, line 61 to 63 deals with forfeiture of rights with respect to retirement. And let it be said, I'm not looking to minimize the impact of these actions. I mean, I think it's certainly a concern. What is the standard in other parts of the law for violations that could lead to being subject to losing your retirement? I'm sensitive to 28-year educators, a principal that had knowledge that some irregularities might have happened, wasn't certain, wasn't sure whether they should investigate or not, and you could create a set of facts around this.
Well, put that in a little bit better context, this is actually one of two bills that has been introduced, one of which has been referred to the Retirement Committee.
Okay.
Right now in current state law, there's a list of offenses that if you're convicted of, you lose the right to participate in the state pension retirement plan. You do get the money, your contributions back that you've made over the year, but you don't get the right to participate in the pension. The bill that I've also introduced that's pending in the Retirement Committee would add this offense as one that would potentially, or that would subject you to loss of the right to participate in the pension system. I think this is just a means of, if that bill is ultimately unsuccessful, this 61 through 63 is not operative. I think it's merely helped, it's put here to guide individuals that will look at it in the future in terms of figuring out what options are available to us. And if that bill is successful, this will be one of the additional enumerated offenses that would exist under state law that would, if a state employee is convicted of, would lose the ability to participate in the state pension plan.
I wouldn't expect you to be able to rattle those off right away offhand. I am interested to know if counsel or anyone knows, is that more of a felony kind of thing? Is that you're getting some actions from over your right shoulder? Nels?
The other felony to which Representative Ramsey referred, the falsifying government documents, is in fact one of those crimes.
Right. And to that end, is this? I'm not sure I have it to the author. I'm not sure I have an opinion on this, but I'm certainly pricked by it. I mean, it's certainly, to me, of all the things in here, to me, this is the. I mean, if other things are a hammer, if other things are a punch, this is a knockout punch.
Well, I would say to you that 61 to 63 has, if this bill passes by itself, this has no legal effect at all in the bill. If I don't know if you serve on the Retirement Committee, but you may have an opportunity.
I do.
So Chairman Golick may have an opportunity to weigh in on that issue, but it's I think it's a different issue. I think this is merely put there if we are successful, and frankly, if we get down the road on through this process and see that bill is not going to make it, we can take it out because it's surplusage at that point.
Okay.
But I think it's merely inserted there as a placeholder right now to guide individuals in the future that are looking at this. You may have another. Stick to deal with in deterring and addressing violators of the law.
And I would just tell you, as a member of the committee and a friend, that this is clearly a stick. I mean, that's a. So I just didn't have any context for knowing if other misdemeanors can be charged that way, if that's consistent or.
Right.
Do you know offhand if there's other misdemeanors?
Well, I'm sure we could pull if one of the aides could grab the title 36 or the title 47 code book, we could probably get that real quick.
Well, let me call on Ms. Bird, and then we'll come back. Ms. Bird.
The author.
I think the light's on behind the mic.
Is it on?
Yep.
Okay.
Thank you.
Thank you, Representative Ramsey. I realize that this has been highlighted recently. Surely this is not the first time this has happened. It may have already happened. How was it handled prior to us trying to do this legislation, number one? And I'm still not clear about how this is going to work. So you're talking about going back to the AG and the PSC. They investigate how many times? I mean, are you charged once or twice, or are you giving them up to 3 times, and then it's gone to the AG? When does the AG kick into there? I'm missing something.
I think when an investigation is conducted by a school system or the PSC, and they reach a conclusion that a violation has potentially occurred, then they will then ask the Attorney General to get involved. There's nothing that precludes the Attorney General, if we vest with them this authority, to investigate themselves from the get-go when one of these statistical red flags are raised through the annual audit process. But in practice, to reiterate what Mr. Peterson said, the way it will unfold is that the school systems and the PSC from the state's perspective and the school system from the local perspective will investigate the statistical anomalies that are raised through the audit process, and then as they get down the road and start to reach a conclusion, then they would then contact the Attorney General and say we feel pretty confident that some violations have occurred here, from a charging from a criminal standpoint, that then would be the Attorney General's responsibility. And you asked another question. I'm sorry. How this has been dealt with before?
Sure.
There was just last year in the summer, the summer of I guess it was 2009. There was an initial round of audits that occurred, and several irregularities were found. An investigation was conducted, and there turned out to be several violations, or several instances where a school official changed a student's answer key, and 2 individuals, as I said earlier, were in fact charged under a felony charge of altering a state document. So this is just meant to provide a specific enumerated offense in the criminal context that really sets forth all of the types of conduct we're trying to get at. Right now, the current law provides for you can potentially be prosecuted for a felony if you actually erase the answers and change the Scantron yourself. But if you stand next to the person and read the answers to them as they're changing the answers, you can't be charged under that altering state document because you haven't physically altered the document. So this is just meant to bring some consistency in the criminal context. This is just bring some consistency and some specificity to the kind of conduct we're trying to get at.
Thank you.
Ms. Benfield.
Yeah, I'm sorry. I'm getting back to the same issue I had before about the Attorney General investigating these allegations. Maybe I'm just not reading the bill thoroughly enough, but I don't see where the Office of Student Achievement is conducting the initial investigation. So if you could point that out to me. And I also pulled the code to see maybe it was in the larger code, and that's why it's not in the bill, but I couldn't find it in the larger code either.
Well, as a practical matter, the Professional Standards Commission actually would end up doing the initial investigation.
Professional Standards Commission. Where does it say that the Professional Standards Commission is conducting the investigation?
I mean, I think they do that and the author will correct me, I think that's their job as a matter of custom and practice whenever there's any sort of malfeasance that's been alleged, and then they may or may not make a referral to the Attorney General's office. Is that right, to the author?
That's exactly right.
Okay.
So how is that outlined here?
I'm not sure we need to outline it here. There's
that's the way they conduct business
that's
now.
That's just their course of doing business in regulating the individuals that are under their jurisdiction, that are licensed under their jurisdiction.
Okay.
Mr. Levitas.
Thank you, Mr. Chairman. I want to get to something, I guess, a little more fundamental. I mean, we're not talking about a very low standard for the conduct here. I mean, in order for somebody to violate this statute, it has to be knowingly and willfully. So this is the most egregious kind of conduct that we're talking about here, right?
And that's exactly, I should have made that point. It's a good point. This, you, especially as a former prosecutor, understand how high of a bar that is. You have to clear willingly and knowingly, that's not something you can accidentally. You can't accidentally commit an offense that we've set out. The offense that we've set out under the law. It has to be willingly and knowingly. I think that's a good point.
I want to share something with you. When as you know, I'm a signer on this bill, so obviously it's something I support. But when we were doing the research on this bill, and it's affected DeKalb County well, as you know, I was struck. I think maybe the best argument for why this needs to be exactly the kind of offense it is didn't come from you, and it didn't come from me. It came from the Georgia Association of Educators, and if you remember back in, I think it was 2009 when this first came to light, Jeff Hubbard, who's the president of the Georgia Association of Educators, said this: "This is one of the worst academic offenses." And the word there is offenses, an educator can do or be accused of because it messes with a child's future. And that's really ultimately what this is all about. It's an offense It's not just a mistake. It's not something, gee whiz, you shouldn't have done. This is an offense committed against children. And there's no other way to look at this, in my opinion. I know people can have varying degrees on what we're talking about, but here you have the president of the Education Association saying himself, this is an offense committed against children. And as such, you put a very high standard in here. And again, I'm a little bit lost to understand what the pushback on this is.
And I agree, it's an offense against children, and also as a parent of a student. One of the most important things that I do and you do is maintain an ongoing dialogue with our children's teachers to know that if are they falling behind, is there something we need to do to help bring resources to bear, whether it be additional tutoring or just we're not going to let you watch TV at night until all your homework's done. So not only is this offense against the children in terms of defrauding them of the knowledge and the resources to stay caught up with their contemporaries, it's also an offense against the parents that are trying to do their best to make sure their son or daughter are keeping up and are able to achieve all that the parents want them to achieve and all the student wants to achieve through their academic endeavors. I think it's a very good point, and I think that quote is right on.
I see no further questions. Oh, I do. Ms. Benfield.
Thank you. And tell me your name again, the Governor's Counsel. Nels Peters was kind enough to offer a suggestion, and he might be better able to explain it, but addressing my concern on page 1, line 20, his suggestion, line 19, is in lieu of anyone to strike that and insert an employee of a local unit of administration, and then that would trigger an investigation by the Office of Professional Standards, whereas anyone doesn't necessarily put it under that office's jurisdiction. So that might help clarify and ensure that the investigation is being done initially by that office, and then once their investigation is complete, if appropriate, it would be referred on to the AG.
And I think that kills two birds with one stone in terms of Vice Chairman Hatfield's concern as well. Do you agree with that, Representative?
Any employee in that context, or any individual charged with administering the assessment, et cetera?
Well, I think if
it doesn't matter.
If a school employee, whether they are actually charged with being in the room administering the test, if they engage in this conduct, I think it's no less egregious. So I think that gets us where we want to get in terms of making sure a student that shows an answer to his desk mate doesn't get charged, which was never the intent. So.
But any individual administering the test would, by definition, be an
of
employee.
Course,
there wouldn't
right.
be anybody
right.
administering who's not otherwise an employee. Is that correct?
Well, does anybody from a private testing company?
No. Volunteers are not supposed to administer the test, but that's not actually in law. Right? That's in the guidance, but it's not a requirement.
Well, Ms. Benfield, Ms. Benfield, did you have anything additional? Because we sort of all jumped into that conversation. Did you? I mean, we know where you're going, and I think we're all in agreement. We just want to make sure that we word it properly to make sure we're capturing where we need to capture.
And I would ask for the input, because I'm not familiar with how this section operates or the existing law operates.
Mr. Peterson, do you want to?
Well, if I may, that occurred to me as I was crafting some language to suggest to Representative Benfield. It would, the only way that this revised language would not cover a test is if a volunteer is on their own initiative without any involvement from anyone at the school is changing answers. And in that context, the PSC would not have jurisdiction to investigate in the first place because it's a volunteer who's not an employee. And I'm not really sure how you cover that sort of thing without unintentionally broadening the scope. And really what we're trying to get at is not so much the unique one volunteer somewhere with no involvement whatsoever from anyone employed by the school, that, you know, trying to reach that kind of unique case may unintentionally broaden the statute a little too far. So it would not cover every conceivable incident of test cheating, but, you know, it may not be possible to do that without being too broad.
Mr. Chairman, I was going to mention the issue about volunteers came up, and it was something that I know that I believe it was last year or a year before I was a volunteer on some testing in my child's school, in elementary school, and basically just to serve as an observer. And we didn't do any participation in actually administering the test, but just observing. But this, you know, I don't know whether or not that the administration intends to get at those people, but certainly they would be in a position to be able to offer assistance or guidance while the test is being administered. Now, I think that's a policy decision as to whether or not they intend to try to get at those volunteers.
I think you're talking about on far on the margins of what we're trying to get at. I think if we, based on what the OSA has found, based on what the individuals, the private companies that provide testing protocol guidance, obviously the individuals with the most opportunity to tamper with tests are going to be school employees.
So the intent is to reach the certificated personnel, really.
I think that in terms of the problem we're trying to address, that would address it.
I don't know whatever the will of the committee is, but I would feel like that, you know, if that's what the administration is reaching for and trying to get at, and that's where we see evidence that that's where the problem has come from, that we should limit the focus to that group,
which I think is what the suggestion offered by Mr. Peterson that was articulated by Representative Benfield. I think that gets at it. And if 2 years from now we find there's a rash of volunteers coming in and inappropriately tampering with tests, I think we could revisit it. But I think this gets at 99% of what we're trying to get at.
Mr. Chairman, I wanted to, while I have the floor, bring up one other issue and some potential language of an amendment that I just sort of jotted down. But one concern that I have, and maybe you can allay my concern some way, but I have concern that a lot of the digging into these testing violations it's coming from an initial statistical analysis that's done, and then they say the statistics don't look right on this particular test, and therefore we conclude that there's been some sort of testing violation or testing irregularities that have occurred. Now, I understand that there might be some value in using the statistical analysis to do some further looking, but I want to make sure that we don't have anybody that's convicted or that forfeits any rights or is subject to any penalty based solely on statistical assessments. And I've sort of written up a little language to that effect. But
Mr. Weirn will no doubt add to my comments. But all the statistical analysis does is provide a look at identifying statistical anomalies in terms of the number of erasures on a test, and it has a threshold by which if you exceed a given number, it provides guidance that you should investigate this. All it is a trigger for an investigation. That nothing more. And if you have a class, for example, where a teacher has taught the students, go ahead and cross out all the wrong answers, so you know not to, when you're going back through, to go and use them, and then at the end of the test go back and erase all the cross outs. I mean, that's the kind of thing you get at during the investigation. But as you know, as a practicing attorney in the criminal law, willingly and knowingly, that's a tough standard to meet.
Well, that's true, but this bill does more than just provide criminal penalties, and it does provide some civil forfeitures, or potentially provides forfeitures in conjunction.
Well, this
with
bill doesn't
other,
provide for that. That's
well,
the
but
other bill.
in conjunction with other bill that you've offered, and it also provides for loss of performance pay consideration and things of this nature, and so and I think there was some language about. Suspension or revocation of certificates.
Which the PSC has that authority existing right now.
Right,
so.
right. But let me ask this follow-up question. In terms of the statistical analyses that they use, is it only looking at erasures, or is there do they look at statistics and say, well, this class performed really, really well above what it was expected to do, and therefore we conclude there must be something wrong here?
I'll let Mr. Weirn speak to that.
No, this particular time looked at changes from wrong answers to right answers, right? So in other words, just alterations that would make scores go up. And just as a point of clarification, it's not that the numbers in certain classrooms looked off. It's that they looked extraordinarily, implausibly off. And even with that extremely high standard, what's called for is, and should always be called for, is kind of more qualitative, interviewing and reviews of documents and procedures and things like that before anyone's, even accused of anything.
Well, in the cases that we've read about, or the schools that we've read about in these articles in the AJC and other papers about the widespread test cheating, has there been investigation done by the PSC that has revealed something more than just statistical anomalies? Or, do we have hardcore evidence in terms of statements from people involved or confessions? Or
well, the two individuals that were charged in DeKalb County confessed.
Okay, well, that covers those. But,
right.
There were apparently a lot of schools where these accusations were being leveled.
And that just the most recent audit is just a month old now.
Right.
So the investigative process is just getting going. And I'll reiterate a comment I made early on. There's not been, not from me or any person involved in this bill, there's not been one allegation that cheating has occurred despite all of those red flags. It's merely a trigger by which we give the PSC and school systems the knowledge that they may need to take a look at these tests.
So you think the media has jumped the gun on?
Well, I don't know that I've read anything in the media that listen, when you have that many schools, when you have red flags raised in that many schools, we're talking about literally thousands of potential tests, children's tests that were subject that were taken in these schools that were red flagged. I think that's a big story, but I don't know that I've read anywhere in the media where they said cheating has occurred in 150 schools. And as for if they have said that, that's certainly not the language that we choose to use.
Yeah, the state board has asked the local education authorities, generally the local school boards, to investigate and give OSA reports on their investigations over the next few months before the end of the school year. And any PSC ethics investigations will follow the results of those.
Okay. Let's do this, Mr. Ramsey. Ms. Abdul Salam, did you have a question? All right, Ms. Abdul Salam, then I want to take it back and for further instruction on going forward.
Yeah, I won't prolong the conversation. I just had a thought as they were discussing the last segment. How is it that they actually test to see about erasures? Because the OCR scan machine can't pick up erasures. They can only pick up the dark marks. So how are you testing for erasures?
Yeah, the scanner, the whole analysis was done by the same company that actually scores the test in the first place. And there's documentation of how this was done on our website, that the report that the company did. But they look at variations of grayscale, and they determine whether the darkest one is the answer, and then they go down to see whether between there and a blank mark, and if there's something in between, that's kind of considered a change.
So the scan picks up the grayscale?
It does.
Okay.
Mm-hmm. And I should add that the company also goes back, and they scanned something like a little over 1 million answer documents, and went back and hand checked 20,000 or so to make sure that it was right.
Thank you. Chairman Ramsey, here's what I'd like to do. I know Ms. Abrams had some amendment language, or some language she'd like to go ahead and put forward. I know that I had a concern as well as the vice chair on the anyone issue. The language, the word, Ms. Travis caught the word inappropriate on line 23. That kind of word scares me. I don't know what that means.
Well, I spoke to Ms. Travis. I think we can take out inappropriate, and I mean, it's any guidance that helps examinees arrive at an answer they wouldn't have otherwise arrived at. So I think that's a simple fix, Mr. Chairman.
Also, there's a concern or alter or interfere with examinees' responses in any way. The vice chair and I were just discussing that earlier in the context of, I mean, what if you have a conversation? Bear with me for 1 second. See, the fact that you've got or after test administration or alter or interfere with that examinee's responses in any way. You know, you have somebody coloring outside the circle or whatever it is, and you've got, they're giving guidance on how to bubble it in or whatever the expression is. I wonder if we might do better just to go ahead and strike that. So strike inappropriate, provide guidance to help examinees arrive at correct answers that they may not have known on their own before, during, or after test administration, semicolon, and just strike the rest. We did not have this bill go through subcommittee, and that was by design. This is an administration bill. It's an important bill. It's a timely issue, obviously, and so I wanted to really have sort of a committee of the whole, for lack of, or have the full committee serve as a subcommittee to go ahead and go through this. I think these are relatively easy fixes, but I do want to go ahead and have this airing first. What I'd ask you to do is to work with the folks that I've mentioned just now, in addition to any other committee member who'd like to be part of that conversation, on a fresh, clean substitute that we can come forward with and move on fairly expeditiously on Wednesday.
Okay.
At our Wednesday meeting, which we'll do at 1:30, probably the same time.
Okay. That sounds like a good plan.
Does that
Mr.
sound
Chairman.
fair?
Yes, sir.
Are there any other questions or concerns with any other? Ms. Abrams, did you have? I see your light. I think just for efficiency's sake, maybe if you could go ahead and get with the author and
I helped her write this language.
I think y'all have
so
already
we'll
discussed,
put it
right?
in I mean, we can put it in the substitute.
Okay. That might be better for all of
And
us.
I'll explain any changes we make from this version to the substitute.
That'd be great.
At the beginning of the meeting.
That'd be great. As soon as that becomes available, we will go ahead, as always, and send that out to members prior to the meeting, again, if we have it,
Okay.
which is not always the case, and I understand that. And we thank you.
Thank you.
Ms. Oliver, thank you for your patience. We do have another bill, so if members could just stick around. This bill, House Bill 1144 of Representative Oliver, also did not go through subcommittee. That was generally by design. It's a very straightforward issue, which I don't think needs a whole lot of vetting, but I think in terms of where it came from and what its motivation is, I just thought it might be nice, or might be more appropriate to have it go to the full committee straight away.
Thank you, Mr. Chairman. I appreciate the opportunity to have a hearing today on 1144. This bill is brought forward on behalf of Commissioner Murray, Commissioner of Department of Juvenile Justice, and Assistant Commissioner Amy Howell. Very simply stated, the purpose of this bill is to give credit for time served to juvenile offenders in the same way that we, by statute, give credit for time served to adult offenders. This bill, as a practical matter, follows the DJJ's very good work over a long period of time under their federal monitoring and exiting the federal monitoring process, that a lot of their work was on the proper use of bed space and size of facilities and capacity of facilities. Following that good work, we also have a significant budget implication that has reduced beds available to DJJ significantly, both in this budget year and next budget year. The reality is that substantial majority of the offenders now in secure bed custody of the facilities of DJJ, which is approximately 900 beds, are offenders that have committed the serious crimes of the designated felony crimes. A good number of those offenders spent time in regional YDCs prior to the time of going forward to the state 900 beds. The purpose of this bill is to treat juvenile offenders in the same way that we treat adult offenders, to give them credit, in effect, for the time they spent in the regional youth development centers as in the state YDCs. Commissioner Murray has been here with us this afternoon. If the committee would like to hear directly
Commissioner, do you have
from
any
him.
comments you'd like to make?
Yes, just briefly. The committee may be aware that last year the Department of Juvenile Justice was able to come out from under the federal oversight that we'd operated under for 11 years, and now we operate a constitutional juvenile system. To some degree, we can control our own destiny. Part of the reason that the state was placed under the federal oversight in 1998 is because of operating grossly overcrowded facilities. Today, as a system, we're not overcrowded. The passage of 1144 will allow us to continue and manage our population. It will allow a greater turnover of beds of juveniles, designated felons coming through the system. And again, it's an issue of fairness, as Representative Oliver stated. It's the same right that's granted adult offenders, and it's our feeling that juvenile offenders should be granted that same right. Normally, they're in the detention centers for a period of about 3 to 4 weeks, although in some cases, juveniles are detained much longer than that. So while they're in that pre-adjudicatory status, they would get credit for that time. That's what 1144 would allow.
Thank you, Commissioner. Questions for the author, for the Commissioner, Ms. Abdul Salam?
Thank you so much, and thank you both for the legislation and the work on this issue. 2 questions, and I'll try to be brief. I understand that with the budget restraints that we're all facing, is it true that you already in the last year or 18 months have actually made some reductions in RYDCs?
Yes. Facilities have been closed. So there's a reduction in beds of over 200, if I'm correct.
Actually, 435 beds.
Okay.
Thank you for that question. We've closed 2 facilities involving secure beds. And again, in spite of that, we remain manageable and constitutional. 1144 will again help us to maintain that status.
Okay.
We, in the analysis of the bed space usage today, it's estimated that passage of this bill will release between 50 and 60 additional beds, again, for the serious offenders, and that's what we want to use that bed space for.
And final follow-up, Mr. Chair. In looking at the language of the bill and the effective date, I assume is when the governor signs it or once it's signed, is there any consideration being given to making it retroactive for people that are currently serving in RYDC? Was there any discussion about that?
I have heard.
Or will
no
it be for
discussion
new
of that.
offenders coming into the system? I'm sorry.
I don't know the answer to that.
I don't believe we've had a retroactive discussion about the bill, although certainly we welcome that, but we would welcome just the opportunity for it to cover juveniles who will come into the system in the future.
Okay. At the appropriate time, I'd like to be recognized for motion.
Duly noted, Mr. Franklin.
Thank you, Mr. Chairman. Just for clarification, it seems like the second section is basically a specific repeal so that the first section can work. Is that?
Yes,
Am
sir.
I understand that right? Great.
Yes, sir.
Thank you. Thank you.
I see no. Thank you. I see no further questions. I see no one else signed up to speak. What is the will of the committee, Ms. Abdul Salam?
I'd like to move due pass.
Ms. Abdul Salam moves due pass of House Bill 1144 LC 294214S, seconded by Mr. Franklin. Are there any amendments? Seeing none, any further discussion? Seeing none, all in favor of the gentlelady's motion, please signify by saying aye. Aye. Opposed? The ayes have it, and the motion is adopted. Thank you, Ms. Oliver.
Thank you, sir.
Thank you all.
Thank you, sir.
Members of the committee, we're on for 9 o'clock tomorrow morning. 9 o'clock tomorrow morning, House Bill 571. That is the sex offender legislation. That will be potentially a vote on that substitute that's been out for a while. 571 tomorrow morning, 9 a.m.